right, so let's go ahead and get started. So welcome everyone. My name is Jody King. I'm the Assistant Director for the Alaska Apex Accelerator. And today we have two amazing women joining us from Kansas in Kansas region, and I will let them introduce themselves and the company that they are joining us from.
Well, I am Nicole Pottroff. With me today is my associate, Annie Birney. I will let her introduce herself, but I'll kind of give you all the spiel on our law firm and what it is that we do. So we are a boutique law firm that solely does federal government contracting, and being in that very narrow field does allow us to get highly specialized expertise in a short amount of time on these topics that we're going to be talking about today, which is why this is really one of my absolute favorite presentations to give, because so many of these are, you know, kind of fun little mistakes in theory and when you're talking about them, but can result in dramatic problems or benefits if you know of the mistake ahead of time. So I'm very excited about this one, but they are going to cover a wide range of topics, just like we do, even in our very niche practice. So we do everything from GAO protests, Court of Federal Claims. We've got one case pending at the Federal Circuit Court of Appeals right now. So we go all the way up to, you know, Supreme Court if we have to. We've got SBA litigation, SBA's Office of Hearings and Appeals. We've got claims and REAs where, you know, the government's not paying you what they're supposed to pay you, things like that. We also do lots and lots of transactional work. So the 8A program, WOSB program, SDVOSB program, and just general small business regulations and requirements. We do all kinds of work in that. We do joint ventures, subcontracts. I mean, if you can tie something to a federal government contract, there's a good chance we can help with it. So we are located in Lawrence, Kansas. Again, I am an equity partner at the firm. My other partner is Shane McCall. And before I pass it over to Annie to introduce herself really quickly, if you have questions that you maybe forget while we're talking or kind of come up later, you know, when we're all sitting on the couch later thinking about nothing but government contracting, as we all do, there are email addresses at the bottom for myself and for Annie. We will almost always get you an immediate response to the extent of we've got your email, we'll answer it as time allows. And we do a great job of making sure, even if it is, you know, maybe a week or two, if we're pretty busy, we will get you an answer to your question as long as it's not legal advice. So I will let Annie introduce herself real quick.
Hello, I'm Annie Birney, and I am an associate attorney at Koprince McCall Pottroff, and I graduated from law school in May at the University of Kansas. So I am still a baby attorney, but I'm very fortunate to get to learn and work under Nicole, who is an expert at everything under this topic. So she has been a great resource for me, and getting to learn all of this and getting to present with y'all today.
Well, that was awfully kind. And Annie, don't let Annie fool you. She is a baby attorney, but she is very capable. She is very, very capable. All right. So let me see how I get to this. Okay. I will do a quick overview of what we're going to talk about, and then Annie's going to get us started on content. We may jump back and forth a little bit too. Don't be alarmed if you hear my a bit more abrasive voice to her much more melodic and pleasing voice come through with some additional comments. If she's got anything to add on mine or vice versa, we may kind of tag team a little bit. For the most part, Annie's going to do about half the presentation and I'm going to do about the second half. So Annie's going to talk to us about small business misconceptions, and these are everything from like size to rights of small businesses, things like that. Proposal misconceptions. These are very, very important ones. These are some of those ones where the difference in a 5-minute, you know, period can mean you have no chance at $1 million award or you're the one getting it. And then I believe I take over on performance misconceptions. So this is kind of once you're in the phase of already performing a government contract. And then we have subcontracting misconceptions. Frankly, we could probably do an entire webinar on subcontracting misconceptions. Maybe we will one of these days. We really enjoy working with Jody, so we'll see. But that point being, we're going to focus on a couple of the big parts of the subcontracting misconceptions that we see, and those that can have very, you know, significant effects on your business. But in a nutshell, subcontracting and the limitation on subcontracting and non-manufacturer rule and 1099s versus employees and all of that fun stuff is much more complex than you would think just based on the plain language of a subcontracting topic. Finally, we will have our miscellaneous misconceptions. Frankly, these are the fun ones. These aren't ones that typically result in huge mistakes for your company. Rather, learning how to maybe even pronounce a word that is probably in our experience the most commonly mispronounced word in all of federal government contracting can really make you look like an all-star when you're in a crowd of people and you're the only one saying it right. So we'll give that to you. Then, as Jody mentioned, we will save questions and answers to the end. Really appreciate you all doing that, and I know that questions come up as we go. The only reason we ask that you hold it to the end is some of the slides kind of follow on topics of the other slides, and we've found that when we go through and ask questions throughout, sometimes it makes the presentation longer than needed because we end up kind of repeating information as we answer questions and then get to that slide later on. So appreciate your patience with us on that one very much. Because we're lawyers, we've got disclaimers. That's just the way it always is. So before we get started, both of these are very important disclaimers. First off, no matter how applicable what we're saying sounds to you or your company, or how spot on we answer one of your questions, please keep in mind that this is not legal advice. This is not individualized legal advice based on your fact patterns, your company, or anything like that. It is educational only, and all we are providing is general information on regulations, on our experience. None of it is actual legal advice. If you find that you benefit some from our generalized advice here, our generalized educational information here, and you would like legal advice, again, reach out and contact us. We do a free 30-minute introductory phone call for any potential new client. Very easily can hop on and find out if we can help or not. And second, and this one's very important in today's day and age, as we're seeing, rapid changes all over the place in the government and the courts everywhere. So this presentation covers the rules that are in effect when the presentation was given. Hopefully, as we checked them yesterday, but things are moving. But keep in mind, they should all be accurate as of right now, this point in time. But if you are watching this at any point in the future, and I do mean any point in the future, don't rely 100% on the laws being the laws. Definitely do a quick check. We try to provide citations throughout for you to go. All you got to do is pop that thing into Google. It'll pop right up. If you want confirmation from us on whether something is still in effect or not, please, again, feel free to email and we'll get back to you. That one's usually a pretty quick answer, so we can get back to you pretty quickly on that. Without further ado, I will allow Annie to take over.
All right, so we're going to start with some small business misconceptions that a lot of people have and that we see often when people come to us with questions. So the first one, these receipts don't count. So calculating annual receipts is one of the ways that SBA will use to determine the size of your small business based on the size standard. But the question often comes up of, well, what constitutes receipts? What am I calculating? So SBA has a regulation that states exactly what is specifically excluded from this term of annual receipts. So note that things like subcontracts, commercial contracts, contracts with other NAICS codes, those are not listed in the regulation as being excluded. So they are included in the receipts. A big one is the contracts with other NAICS codes. Often people assume that since this is for calculating size, you would just include the contracts under your primary NAICS code for calculating receipts. But if you have contracts with other NAICS codes outside of your primary, all of those will be included in the calculation. So it's total receipts of the concern. And then the ones that they specifically exclude from the calculation are things like sales taxes, inter-affiliate transactions, so proceeds from transactions between a company and its affiliates, and then some proportion of joint venture receipts. So when a company is part of a joint venture and calculating annual receipts for its individual company, you'll include the proportionate share of joint venture receipts. So SBA clarifies that proportionate share is essentially the percentage of the joint partner's share of work performed in the joint venture. So that percentage will be included in your annual receipts for purposes of calculating your business's size.
Yeah, that was wonderful, Annie. The only thing I wanted to add was a big misconception. I think Annie hit the first one on the head, but I think there's really two. One is, yeah, what about contracts with other NAICS codes? If we are having to be small under a specific NAICS code, then why would our work under other NAICS codes matter? But that is not the case. It is every NAICS code you work under. The second one, I think a lot of people ask, well, if this is about government contracting, then do I have to count my private or commercial contract receipts as well? And the answer is obviously yes here. That's a big old rule right there, 13 CFR 121-104, very, very long rule, but it's worth a read for any small business out there that is not sure how to calculate receipts. Also keep in mind, most of you are probably well aware of this, but the look back period for what receipts you have to count in your size used to be 3, and then there was a runway extension period where you could do 3 or 5, whichever made you smaller, and now it is officially 5 years. If you have not been in business for 5 years, you do kind of a prorated thing for how long you have been in business, but there's a lot more information in that regulation if you're not as aware on these things. And then for the proportion of the JV receipts, do keep in mind that that proportion is also important that stays in line with the joint venture regulations, which require a certain portion of work being done by one of the members for most JVs, unless it's just between two small businesses doing small business work, and that the profits are divided a certain way. So keep in mind there's kind of a trio of rules you have to pay attention to when you are calculating the proportion of JV receipts. And then I will go to the next slide and let Annie take back over.
Thank you, Nicole. We appreciate your expertise and wealth of knowledge on these topics. We're very blessed to have her today. So number 2 misconception, I need an SBA approved mentor-protégé agreement to submit a proposal on a small business set-aside contract as a joint venture. So under the SBA regs, if the joint venture is between 2 entities that would already qualify as small businesses individually, then you qualify as a joint venture for those small set-aside contracts. The purpose and benefit of an NPA comes into play when a joint venture is going to include a small business and an other than small business that might not be able to qualify for a set-aside on its own, but they're trying to compete for, say, a small business contract that the small business qualifies for. So that's when the NPA can come into play and benefit those other than small businesses. But if both partners of the joint venture qualify, then you don't need to worry about the NPA. And then another thing to note, if you are going to have an NPA before your joint venture, it must be approved. The NPA must be SBA approved, and that needs to be approved prior to submitting any bids on small business set-asides as the joint venture. So just keep in mind that you would need to get your NPA approved by SBA before pursuing joint venture contracts together.
And that point on timing was a fantastic one, Annie, thank you. We see that a lot, actually, and we see this question a lot. We've even had agency representatives unsure as to whether a mentor-protégé agreement was needed. And so this sums it up nicely. I just wanted to add a couple quick things. So for one, when we're talking about all small, keep in mind, we are also talking about these socioeconomic programs, but what the rule is essentially, as long as if you're going for 8A work, then you don't need an MPA, and I'm just gonna say MPA because it's nice and short. You don't need an MPA if you have one 8A venturer, which is obviously small because you have to be small to be in the 8A program, and you have another venturer that is also small. Now, I backtrack a bit because I guess I misled when I said you have to be small to be in the 8A program. You do, but that's under your primary NAICS code. And the question of whether you are small and need an MPA or not is based on the contract you're going to be bidding. So that is why sometimes we have clients come to us and say, hey, we've got a small, SDVOSB, WOSB company, and we want to work with them. And we are on the upper end of small. So we are still small for a few NAICS codes, but not all of them. Sometimes in that case, we will help them with a joint venture to pursue some of the things they still can, but we will also be working on a mentor-protégé agreement for work that is in those NAICS codes, knowing that that second entity is likely to exceed those soon. The only other thing I'll add to this one is, even if you do not need an MPA to do your JV, I have done many MPAs between small businesses where kind of usually situations like I just described. One is bigger, more experienced, even though it's still small. One is maybe a baby or a brand new company. In those situations, affiliation is still a concern. Now, through a joint venture, you have the ability to share a lot of resources and work together very closely. But I think the best rule of thumb to keep in mind is, if at any point in time your joint venture partners start assisting each other in ways that are not directly related to the JV and the contracts you're performing. So if someone randomly says, hey, I've got this other proposal, since you're great at this, could you take a look? Things like that could lead to affiliation. So there are times when people get MPAs, even if they don't need them for size purposes. So do keep that in mind.
Okay. The next misconception: if my SAM profile says I'm a small business, I am small for the year and I only have to update SAM annually. So yes, businesses are required to update SAM annually, but keep in mind that when a company is submitting a bid, the representations and certifications on SAM must be complete, accurate, current as of the day you are submitting those proposals. And then this includes registering your joint ventures and keeping those up to date as well. And then if SBA finds a company is not small under the size determination that is represented in their SAM profile, the company has to update its size in SAM. And if they fail to do this within 2 days, then SBA will go ahead and update it for them.
Yeah, and that one is actually a new rule. The last time we gave this presentation, it was a proposed rule, and so now it is an actual rule. The only other thing I will note is, regarding registering your JV in SAM, there was a point in time, knock on wood, I believe it's gotten much better, but there was a point in time where SAM was just having lots of delays. I had one client tell me that, I don't know if this is true because I've never registered in SAM, but one client did tell me that it was just essentially a 6-week wait period without a doubt. Like, that's just, you have to wait 6 weeks to have a updated registration in SAM. Now, while I don't see any rules or policies or anything like that, there was a point in time when that was actually pretty close to the average we were seeing. I only say that because I have seen far too many. We've seen protests, we've seen lost awards because a JV did everything right. They had all of their documents executed. They even did their addendums like great clients, which so many forget to do. And we have to say, oh, no, make sure you do that before you bid. But all of those things can be done perfectly right if you are not updated, registered in SAM properly and accurately and currently. Most contracts have a provision that literally prohibits award being made to you. So keep in mind, even if somehow the CO didn't realize that and made the award, you would be bound to lose it in a protest. So I always recommend, as soon as someone comes to me and starts talking about JVs, even when it's just an idea on the cusp, and they are obviously going to be the managing venturer because they're the one with all the statuses, I always suggest picking a name and registering it in SAM right away, just because that is the thing that takes the longest. People always think that we as attorneys are going to take the longest. It's not a bad assumption, but on JVs, we can write those pretty darn quickly, and there's a lot that comes straight from the regs on those, so they're not extremely complex when it comes to negotiating. So please make sure your SAM is updated. And if at any point it is not, the first thing that you want to do, if you are still bidding on something but your SAM it says it's pending or something like that, is just communicate. I think it's great to communicate. I have had a case where we communicated, and though I will say I think a protest might have smashed us on that one, we were not protested, and they agreed that it had actually been SAM's mishap that caused the problem. So just communicate about it. And then also take a look at your solicitation, because there is a little known FAR provision that sometimes is the alternative for the standard baseline one. And that one actually says it's okay if your SAM is not 100% updated, registered at the time of bidding, as long as it is done by the time of award. So that is in some of them. So not end of the world if you're wanting to bid something tomorrow and your SAM still shows pending, but go see what your contract says and communicate about it. And that's just from some personal experience that I know. I don't think Annie was around when I had that one, so I'm gonna let her take back over.
Okay, this one is a big one that we see a lot. Misconception is that I used a standard operating agreement or bylaws that I found online or I had drafted by AI or a generalist attorney. So I'm sure to qualify for these socioeconomic programs. We have seen countless instances where an application is denied by SBA based on the language that an applicant's corporate documents use, which usually can come from these standard agreements that may be compliant for the state's corporation laws, but will not work under SBA's control requirements, because these can affect the qualifying participant applicant's ability to have unconditional control over the socioeconomic program. And based on even just small provisions that are found in these agreements, so any supermajority voting provisions, a lot of times an application will be denied if there's language about requiring unanimous consent of the members. So that would be, SBA would see this as indicating, well, at the end of the day, the qualifying applicant doesn't have the final say because they have to have unanimous consent with these other minority owners. Right of first refusal provisions, if the minority owners have a right of first refusal, this could also be interpreted in that way of the qualifying majority owner not having that unconditional ownership. Tag-along, drag-along provisions, and then commercially customary control in joint ventures. So for a joint venture, the language in the JVA, the managing venture needs to have control of the day-to-day management and administration of the contract performance for the joint venture. But for joint ventures, the other partners are allowed to participate in the corporate governance activities that are commercially customary. Of course, there's not really a definition to help us out with commercially customary, but typically this would just mean the other joint venture non-managing partners would have a say in extraordinary actions the joint venture takes. But at the end of the day, if it's a day-to-day business decision, then the managing venture needs to have control. And then various SBA and OHA decisions have interpreted these requirements. We have so many blogs over this that provide examples of what SBA does not like to see, and even just, I think we have one blog where SBA even looking at down to the language in the meeting minutes of a corporation. So they can interpret anything in the documents as a way of the qualifying majority owner not having full control. So just keep that in mind.
Yeah, Annie definitely nailed it with that one. With the commercially customary too, as she said, that's all it says in that joint venture regulation. It says that the joint qualifying venturer must have control, but it then says that the other venture can participate in management as is commercially customary. Appreciate the SBA in a lot of ways, but don't appreciate that we got zero info on what that meant. So this is one of the primary examples as to why having an attorney like one of us or any other firm that specializes in what we do, and I'm going to be a little biased here, but it's for a good reason. There are lots of big firms out there that dabble in what we do and dabble in other areas of law. And frankly, I will go toe-to-toe with any one of them, even ones with 10 times my experience generally in practicing law, because this is such a niche area of law and it is so difficult to be an expert in this area unless you are doing it the way that our lovely our founding partner, Stephen Koprince, decided to do it and has worked so well ever since, which is it's all we do. We do not do any state law, and we do have the blog, as Annie said, that makes us stay up to date on things like, okay, we do have this commercially customary term. What does it mean? Well, we've got an entire memo we've done for clients that says what has been found to be commercially customary and what has not. So my little brother, I always joke about this, always tells me that, AI is coming for my job all the time. And I make a joke that, I do government work. I do work with the government. So I don't think predictability is going to be something that's super easy and obvious for AI to figure out in these cases. And so another quick example, and I'll move on to the next one after that. Standard operating agreement. I've had plenty of clients come to me and say, all right, here, you write my joint venture agreement, but I'm going to write we have an operating agreement. And they take their company operating agreement or one they found online or even an AI one, and they just, say, we've got that. Well, I always insist that they send it so I can make sure yes, that it does not conflict with the JV. And most of the time, the biggest thing we see is it discusses distribution of profits in line with ownership. And while it can be okay if you have a 51-49% ownership split in a JV to divide profits that way, you have to ensure that you also include that you understand profits must be divided in accordance with work performed, and there is a 40% minimum of work performed by the qualifying venturer. So little things like that. And when I tell you we can write these JVs quick, I'm telling you, we can write a JV agreement very quickly, very efficiently, and very professionally. Only issues we've ever had are where clients did not realize they needed to fill out the addendum, regardless of how many comments we put on the draft. So we are good at them. It does not take long. It is not extremely expensive. And I promise you, having us or another firm like us do it saves a lot of time, money, and headache in the end, because no one wants to have two companies working together get an amazing award and lose it over a simple flaw in an agreement. That is awful, and that is quite literally what they will do with joint ventures.
Okay, my 1099 is an employee for purposes of meeting the limitations on subcontracting. So the limitations on subcontracting rule limits how much work assigned to a prime contractor can then be subcontracted out by the prime contractor to subcontractors that are not similarly situated, which is a mouthful. The goal is to essentially make sure that small businesses that are the prime contractor are not serving as pass-throughs essentially for these larger companies to come in and take the advantage of getting contracts under these socioeconomic programs or small business set-asides by saying they're the subcontractor and just using the small business as prime, but then doing all the work. And so again, this rule applies to subcontractors that are not similarly situated. So similarly situated would be a subcontractor that's in the same socioeconomic designation as what's required by the prime contract. So if they're both similarly situated, then it will not be included in the subcontractor limitations. Now for independent contractors, the regulations do state that an independent contractor will be considered a subcontractor. So again, the prime would have to limit the amount of work they could subcontract out to the independent contractor. But back to that similarly situated entity, there may be cases where the independent contractor could count toward meeting the applicable limitation on subcontracting because they're a similarly situated entity.
Okay, bear with me on this one, because as I said, we can do an entire presentation on this, and I'm going to try not to do that right now.
Yes.
But the important thing to keep in mind is when it comes to subcontracting in federal government contracting, and when you are looking at the limitations on subcontracting and the other rules, that the non-manufacturer rule, things like that, that the actual limitation on subcontracting outside of the title does not really focus on the word subcontract. It merely says a prime contractor may not pay out to another entity, another person, a certain portion of the money, depending on what kind of contract it is. So for services contract, 50% of the total amount paid by the government. So that was a choice. That was definitely purposeful, in that we used to get a lot of questions about what a subcontract was. Is a vendor a subcontractor? Is a 1099 a subcontractor? Is someone you're renting your building from a subcontractor? Now, the big thing to keep in mind there is it is contract specific. So if you're renting a building for 10 years and you're doing all of your contracts out of it, that one should technically not count. However, almost anything that you are strictly using for one contract or two, but you are giving a set proportion of money to that other individual or company, will count for that limitation. So do keep in mind, default to yes it is, unless you've got a professional telling you no it's not. And the similarly situated entity, Annie said this, but I am just going to make sure I hammer down on it a bit. A similarly situated entity is not just similar to you as the prime contractor. So you can be a small business and they're a small business and you're thinking, great, we're similarly situated. But if the contract is WOSB and you're WOSB and they are not similarly situated for that contract. So I just wanted to add that. Keep in mind, it's based both on matching the prime contract and the prime contractor status.
Okay, the limitation on subcontracting and non-manufacturer rule don't apply to the socioeconomic programs below the simplified acquisition threshold. Okay, this one I can attest. When I first read the regulation, I thought this too, based on the language and wording of SBA
yes,
in this, that it did take me a minute to break it down. So I really would have appreciated this slide when I first read it. But they actually do not apply to small business set-aside contracts below the simplified acquisition threshold, but they do apply to all, so the other ones, so 8A, SDVOSB, VOSB, WOSB, EDWOSB, and HUBZone contracts, regardless of value. So the rule will apply in two situations then: a contract set aside for small businesses that does have a value above the simplified acquisition threshold, or a contract set aside or sole sourced for the socioeconomic programs I just mentioned and that are listed on the screen.
Yeah, and just to, back you up on your feelings there, same for so many people. The way the regulation is written is it's in the intro of saying when it applies. It basically says it only applies to small business government contracts above the simplified acquisition threshold and WOSB 8A HUBZone. And so just the kind of juxtaposition without coming in and saying at any value or something like that, it does almost read as, oh yeah, all of those things as long as they're above the simplified acquisition threshold. And that is not the case. So just wanted to confirm you were not alone there, Annie.
Thank you.
Yes.
Okay, I am not a manufacturer. A misconception is I don't manufacture anything, so I am a non-manufacturer. So to qualify as a small business under most set-aside or sole source contracts that are seeking manufactured products or supplies, SBA does require that the offer requires the offer to be the item's manufacturer or comply with the non-manufacturer rule. But unlike this misconception, there actually are 4 requirements that the offer must meet to actually qualify as a non-manufacturer. So it's not just, well, I don't manufacture anything. So the 4 requirements include the offer can't exceed 500 employees. They must be primarily engaged in the retail or wholesale trade and normally sell that type of item that's being supplied. They must take ownership or possession of the item being supplied with their own personnel, equipment, or facilities in the manner that is common within that industry's practice. And then lastly, the item must be manufactured or produced by a small business in the United States. There is a caveat to that if the requirement has been waived, but under this 4th requirement, usually then you're using a small business and manufacturer. So you will need to meet these requirements even if you say you don't manufacture anything.
Yeah, and we get a lot of confusion on this one, to be honest, and for good reason, because it's another one of those, and I promise this is not shameless plugging of our firm. I advise you to seek any GovCon firm out for help with things like this, but there's a lot of very nuanced case law. The 4 requirements that Annie just listed for you, I mean, what is taking possession? Is assuming risk, is assuming liability taking possession? If you're putting something into your facility, is it parts of the thing? Are they assembled there? There's all kinds of questions that we get when it comes to this. And the other big one we get is, how does this fit in with the limitation on subcontracting? And it is also a very common misconception that you have to do both or that you have to do the non-manufacturer rule. What the non-manufacturer rule was meant to be is an exception to the limitation on subcontracting. So do keep in mind, even in a supplies contract, there is a limitation on subcontracting. I believe that's also 50%. So you can follow that. So you can still have some kind of large business supplier under that. Now, if you can't meet that, which tends to be the case for a lot of suppliers and is why this rule came out, that's when you are able to rely on this one. And as Annie said, there is a waiver. There's actually two waivers. You can get a class waiver or an individual waiver, meaning a class waiver of an entire type of something that is only produced by large businesses or businesses outside the US. And then there's an individual waiver. And so if you ever think you physically cannot comply with this on a contract, don't wait until bidding time, but reach out to your CO and ask if they would be willing to, or if they are already considering a individual waiver of that fourth requirement. But that does only waive the fourth requirement of that test. You still have to meet the other ones in order to use this. Otherwise, you got to go back to the limitation on subcontracting. Okay.
Now we'll move on to proposal misconceptions. Okay, I can't ask. So very common misconception that we actually just had a client where we were dealing with this was that unless there is a formal Q&A, I can't call or email a contracting officer with a concern about an RFI or a solicitation. So many contractors will wait and ask a question or clarify something later on, or they feel like they can kind of explain more of their proposal during formal discussions or oral presentations. However, there is no restriction on contacting the CO with any questions or confusions that you might have based on the solicitation terms or your interpretation of what you're supposed to submit. In fact, the FAR even provides a regulation that states that the exchange of information between potential offers and COs is actually encouraged. So keep that in mind. Also, general information about the solicitation can be disclosed at any time. You only will run into issues if the CO is disclosing information that is necessary for preparing the proposal to only one offer, but is not giving that out to others. So that information will need to be made publicly available to all of the offers, just to make sure there's fair competition. And then we've seen a lot of times where the solicitation terms are confusing or they contradict each other. And often, unfortunately, an offer waits until they're not awarded the bid and then they want to protest. But because the contractor didn't raise this in a pre-award protest, the protest will likely be held as untimely. So before even considering a pre-award protest, simply ask your CO for further clarification on any ambiguities or any confusion, clarity that arises from the terms, because then if the contracting officer refuses to answer your question or it's still confusing, you might still have that pre-award protest in your back pocket that you can use after that.
Yes, and I will harp on this one a tiny bit, but only because I did a big old, I think it was a 3-part or 2-part blog. I don't remember, but it was lots of blogs. And there it's called, I can maybe get the link put in the chat at the end of this when I'm not controlling slides anymore, but it is called, Who Are You Gonna Call Your Contracting Officer? Yes, I know, I'm adorable.
Great title.
But in a nutshell, there are these incredible memos that frankly every single federal government employee, federal government representative, federal government contractor, and subcontractor should read, and they are the OMB memos on communications with industry. And they were first, I think, like 2011 or 12, and then they were basically reissued in 2016 or 17, and they are fantastic. They clear up so many misconceptions. There is just a widespread, insidious misconception that you cannot talk to your CO at all during a solicitation phase, even prior to it, that you can't market yourself to your CO, that you can't ask questions. And Annie did a great job of telling you what those limits are. And it's just important to keep in mind, it's really not almost ever, I'm going to say almost ever to be safe as an attorney, it's almost never on the actual contractor to have to be cautious. You can ask your CO just about anything. If your CO can say, oh yeah, that requirement's on page 5, you must have just missed it, and you say, okay, great, thanks, carry on, that's fine. Now, if your CO says, oh, well, that's a little cryptic, but what we're really trying to get at is XYZ. In that situation, it is then on your CO to publicly let everybody else that could be bidding on this, or if it's a closed, if it's an awardee pool or something, to let everybody know what they've told you, because it is an interpretation that could benefit your proposal. And so if that happens, it doesn't hurt to also say, oh, are you going to do a formal amendment for that one just to make sure we're all on the same page, or something along those lines. And finally, as Annie said, we are really big fans. You think as attorneys we want to litigate, but really, truly do not. We don't. Why? Because it's expensive. There's red tape. Anytime we can write a letter without all of the trouble and just say, especially in situations where there's some confusion in the solicitation. Spoiler alert, the agencies don't always write, or sometimes ever write, their own solicitations. They're written by those hired to write solicitations that know what those solicitations are about. But mistakes happen. So often an agency has no idea if there's an inconsistency. I've had construction clients say, there's something written into this that is physically impossible, scientifically impossible. Okay, well, we will almost always try a quick little reach out first, because I can't tell you how many times we've succeeded without having to file a protest, and the COs do really appreciate, hey, thanks for just giving me the heads up, we're fixing that now. They appreciate that a lot. Now, only thing, keep in mind, your pre-award protest is going to be due at the time of bidding, so be very proactive. You find an issue, you reach out immediately, so that if you do not get an answer or don't get one that resolves it, you do have time to file that protest.
Misconception number 9, I'm scared to submit proposals to the government. Can't competitors get them under the Freedom of Information Act? So the FAR provides that a proposal the government cannot disclose it under FOIA. Now, the exception to this is if the proposal is then incorporated into the contract, but the FAR clearly protects the solicitation proposal information under FOIA. And this has actually been strengthened a lot since recently. So the FOIA exemption that's often applicable for these proposal submissions is exemption 4. So trade secrets or commercial or financial information that is confidential or privileged. And previously, the term confidential, the court would look at this in terms of whether that information could cause substantial competitive harm. So the government could release information that was in the proposal, and it was analyzed as confidential under this. Well, was that information actually cause competitive harm? But in a 2019 Supreme Court case, Argus Leader Media, SCOTUS found that the term confidential in this exemption should be using the standard Webster dictionary definition of confidential, so more leaning toward private or secret, and typically where the information is going to be treated as private by the owner and given assurance by the government that the information will be private. And so since this FAR regulation, FAR 24202, provides this assurance to contractors, it kind of strengthens the backing that this cannot be disclosed under FOIA and under the regulation.
Yeah, and the only thing I want to add to this one, because if you're anything like me and tend to have anxiety wherever you see unless or but, it does say unless the proposal is incorporated into the contract. But please do keep in mind, even where a proposal is incorporated into the contract, there are still restrictions on what the government can put into a public contract. It's under the Procurement Integrity Act, the PIA. And so even if you are not protected by the FOIA exemption, you can go straight to that PIA and make sure that anything that is basically your competitive advantage, your structured pricing, profit margins, the way that you're performing work, your any kind of intellectual property rights, there's a lot of different things in there that you can still find a way to make sure the government knows it cannot disclose your information. Because yes, a contract becomes not FOIA exempt, and anything in it is not FOIA exempt for the most part. But if there were to be, there is also sometimes situations where FOIA will provide documents, but will do so with redactions. So it's important to stay on top of that and know what of your information is being put out there, because you are the one that has to basically come up to those defenses.
Misconception: once the proposal due date has passed, I can never submit new or additional information unless the government requests it. So a potential contractor may submit, and the government usually must consider the new information that regards responsibility up to the date of award. So the contracting officer has to obtain information regarding the responsibility of prospective contracts, including generally new information that can come up during the process. Responsibility determinations, this can include making sure the offer has adequate financial resources, can be compliance with delivery or performance schedule, their past performance record, having a satisfactory record of integrity and business ethics. So things along that line where the CO generally has to still keep considering that information up to the date of award. Okay. Email proposal problems. My emailed proposal is timely so long as I hit send before the moment proposals are due. An emailed proposal generally must arrive by the moment proposals are due. FAR provides that a proposal has to be submitted so as to reach the government office designated in the solicitation by the time specified in the solicitation. So if the solicitation requires that you submit your proposal through a specific software and you're having trouble figuring out the software, or there's a glitch with the program and you go ahead and email it instead, this too could also be considered late as well, just because you didn't do it in the location that it was designated. Or if you're a minute late, we've seen that a lot, or 30 seconds, 40 seconds. They can be pretty strict about it, so it's better to allow ample time. You can find several cases on our blog that serve as a friendly reminder and warning that you should allow ample time to submit your proposal and make sure the software or program or whatever is required for submission is working. Now, there are limited exceptions to when your proposal is submitted late. One being if there's, say, an interruption to normal government processes, but this is still extremely hard to meet. We have a blog that touches on a case where the online government portal that they were supposed to submit the proposal to had a glitch, so the offer wasn't able to submit. And GAO still held that this glitch was not an interruption of normal government processes. So keep that in mind, that there's not a lot of grace for glitches or something that might happen to just your software.
Yeah, and this one is just so important. I am a procrastinator, not by choice. I work much better under a tight deadline. Otherwise, I'm an overthinker. I'm sure I'm not the only business owner out there that does this. Here, it can be, well, anywhere really, but it can be highly problematic. So there are few exceptions to this. There's several more spelled out and we will not go through all of them, but some of them have to do with essentially ensuring that the proposal is received by the agency in other forms. So if you can get your proposal done in time to overnight a hard copy to the agency with receipt confirmed, that is potentially an exception you can rely on. I always suggest, yeah, if you feel like there could be an issue with the portal or with an email, just send it every way that you can, marking it confidential, of course. But as Annie said, there could easily be a problem. I mean, we've seen issues, I'm not even kidding, I've been part of protests, y'all, where somebody submitted a proposal and it did not get to the agency's inbox for whatever reason for 4 hours and was still deemed late. And we all know how email works and how emails happen. So the only thing I'll add to that goes right back to what I was harping on before, communicating with your contracting officer. Another thing these cases will look at and have looked at is, did you try, or did you diligently pursue making sure it got there, number one, and confirming its receipt, number two. And one of the times I was able to get an agency to bend even without having to go protest was where they said receipt confirmed, and then later came back and said one of our links didn't work or something like that. I can't remember, it was a long time ago. And we argued with them, then, you know, don't tell us confirm receipt if you actually didn't receive the proposal itself, and they agreed that was probably misleading and that we probably would have continued sending it had they not misled us. So things like that are good ways to do it, but in a nutshell, do not wait to the last minute. Do not depend on technology. It's just, you just can't. You know, you can depend on yourself. So.
Okay, number 12, I think I'll submit one bid as prime, another with a joint venture partner, and then what the heck, one as a subcontractor too. So bidding against yourself, this could be viewed as an antitrust violation under the FAR, but it also can be considered collusion and could possibly violate the FAR's Certificate of Independent Price Determination. So this deals with making sure the certification is that the offer has arrived at its prices and independently and has not knowingly disclosed these to any other offer. So bidding against yourself even can mean in terms of colluding with these other offers to try and lower prices of that such. So if you're submitting bids with multiple JVs or with prime, subcontractor, etc., then you could be violating this certification. And then for SBA regulations, they now provide that you just cannot be a joint venture partner on more than one joint venture that submits an offer for a specific solicitation. So again, just being for that one specific solicitation, having one joint venture in the mix is the rule.
Yes, and I'll jump in real quick, Annie, because I know you were not around when we had the lovely CIO SP4 solicitation and about 1 million clients trying to bid on it. But I only bring this up, it is not really but C is not quite the appropriate label for it because it is still following this rule. And the reason why is CIO SP4, although commonly referred to as one solicitation, and for anyone not aware, just a giant MAC, you know, OASIS, STARS, all of those giant multiple award contracts, those IDIQs, many of them have now started dividing into multiple solicitations. And even though you'll hear, oh, the CIO SP4 solicitation, they're usually referring to whichever one they qualify for. So CIO SP4 had pools, so you could be in the UFB pool, the small business pool, the unrestricted pool, the SDVOSB, and the HUBZone pool. And that is why I brought that up, because I remember reading that and being like, what, this is crazy. This could, everybody's going to be violating things in the FAR, but it's because they keep the pools separate. The work is different, things like that. However, you still need to be very aware of what the restrictions in FAR 3.3 are, and reading that clause at the bottom, that FAR 52.2032. Because if you're at all saying to yourself, I didn't sign any certificate of independent price determination, well, if you signed a government contract, you sure did. So if you sign your proposal, you did. I mean, submitting it is simply attesting to these things and agreeing to these certifications. So keep in mind that even where you have these large contracts that do allow you to bid in multiple ways, you still do have some restrictions. This is a newer rule about the joint ventures. There is also a newer rule, I should have added to the slide, but about mentors and how mentors you cannot be a mentor in 2 JVs and bid with both JVs on the same solicitation. And that's because they don't want the mentors, protégés competing against each other. So there are still limitations even on the ones that have some allowances, and you always want to make sure you are not even giving the appearance of collusion or any dependent price, speaking about your prices with one another. And the policy behind that is simply, my favorite, easiest way to describe it for anyone that's wondering what the heck I'm talking about is if you've got 3 bidders on a contract, one of them is a prime, company A. Company A is a subcontract for the next bidder, and then company A is part of a JV for the third one. Well, if company A is going to be the only one that can provide one of those supplies, and they know there's only 3 bidders, and it's a part of all 3 bids, it can basically make those prices higher, and that is not serving any of the policies we look for in federal government contracting as the taxpayers who have to foot those bills. So,
okay. The big misconception here is that people think that an agency has to consider the past performance of your subcontractor, especially if they're big, household name, that it's going to be what gets you over the line and impress the agency enough to become the awardee. First, check your solicitation. The FAR provides only that the agency should consider, but is not required to consider, the past performance of major and significant subcontractors. There is a new SBA regulation where when the prime contractor can't independently demonstrate the capabilities and past performance that's required for that award, then the agency must consider the capabilities and past performance of the small subcontractor that is listed in the prime's proposal as a first-tier subcontractor. But again, it has to still be only a small subcontractors that they'll consider for that.
And all I'll add to this one very quickly is we are seeing, or have been seeing, a bit of a policy shift toward requiring more agency requirements to actually evaluate things like joint venture experience. Now there are the joint venture rules. Obviously a joint venture doesn't have its own and you have to consider the ventures, but I'm talking more like, as part of a joint venture, I did this and now I want to use that. So a lot of policies and rules are moving in the direction of requiring agencies to consider those things. There's even a newer rule about an agency having to consider work that was done for a large business as a small business subcontractor. You now have a right to request basically a CPARS type thing from them, and the agency must consider that as well. So do keep in mind, we are moving in the direction, but Annie nailed it. Look at the solicitation, because the solicitation, until the law is hard, black letter law telling you what the agency has to consider, then it really is, solicitation is king. So you want to look at that and see what it says. And if it is at all unclear, make sure you ask your CO. And the only other thing I'll add is one of the 2 million reasons that every single prime sub team should have a teaming agreement. This is another one. Having the teaming agreement, a lot of the solicitations that do allow it, they do contain language that says like major or significant sub. And so you can't just throw a name out there in your proposal. You have to actually show a teaming agreement that shows what work they're going to be doing and how they will be major or significant. So keep that in mind as well. All right. Performance misconceptions. And I know we're probably a little over time because I'm a little long-winded. So I'm going to go through these fairly quickly. But again, hang on to those questions. And if you've got any, we can elaborate where we need to. So, nice business card. Oh, this is my least favorite because it's so damaging. So anyone who carries a government business card, like a COR, can order me to do additional or changed work. This is such a common misconception. Except in very unusual circumstances, essentially being where the solicitation specifically calls out the ability for the COR or the CS to make a certain change that is delegated by the CO, him or herself. That's really the most, the only other exception I would say is where the CO is, injured, sick, passes away, something happens and there's not another CO immediately and direction has to come from someone else. But even then, you still want to seek something in writing from the immediate next CO. So most of the time it is only going to be the CO. Now you're probably thinking, okay, great, no big deal. That means I listen to the CO, I ignore everybody else. And it sounds easy, right? But the problem with this is, and also they need to be acting within the scope of their authority. So keeping in mind too, that if a contracting officer simply tells you to do something, whereas you believe it is absolutely a contract modification, you need to ask for that in writing as a contract modification. That is the safest way to make sure you get paid for it. So what we see happen far too often is a COR, on a power trip, goes around and starts, the example that my mentor used to always give that I now give to is you're fixing a bridge as part of a construction contract for the United States. And they say, oh, hey, that area over there next to the bridge actually has some rubble and stuff, not from you all, but from before. Can you just clean that up when you're cleaning up your own rubble? It doesn't sound like a big deal, right? And a nice COR asks you to do that and you're making money on your contract and you're like, yeah, no big deal. And you add that to your costs. Well, unfortunately, there has not been like any judges out there willing to look at that and say, yep, you're entitled to that cost. If you do not have a written modification from the CO, you could be out. You could also risk, in the opposite, a termination for default. So same example, but the contracting officer representative, the COR, says, hey, you know, we told you to clean up after you finish this bridge, but actually we'll have another crew do that. You guys just get out of here. You're doing great. And you guys, great, pack up and go home. Well, then you're risking a termination for default because you did not finish what the contract said you're supposed to do. And there is not a written modification confirming that. So this is really important because even very intelligent contractors, I mean, I understand you're not a one-man band. You've got everybody all around. You've got subcontractors, and people get orders and they see badges and they don't know who they're coming from. Miscommunications happen. This is another really good reason I like to write stuff like this into my subcontracts, into my joint venture agreements, if I can, to put everyone on notice. I like to say the sub should not be communicating with the government, and if they are, they need to communicate all the details of it to the prime. That is also to prevent things like a sub saying, oh, well, we were told to do all this extra stuff, and then them billing the prime, and then the prime trying to bill the CO, and then the agency, and then nobody gets paid. So big one to keep in mind. Okay, the government won't play ball. So misconception is that if the government is just not responding to you at all regarding the administration of your contract, that there's nothing you can do. The contract doesn't say anything about the government having to respond to you by a certain time or in a certain way. And good news, because this is more common than I would like it to be, is there is a unwritten rule that is implied, and this has been held consistently. This is fundamental law. There's an implied duty of good faith and fair dealing and cooperation and non-interference, and essentially you can hold the government to a breach of the contract if they fail to reasonably respond to you as the contractor in your questions and otherwise fail to reasonably administer the contract. So really good thing to know. It's something we throw into a lot of our claims and REAs where we felt like simple changes could have been made to make everybody happier if we had just gotten the feedback we needed or the answers we needed. So it's important to know that the government does have duties to you, whether it says so in the contract or not. All right, the government has the right to unilaterally modify my contract. Sometimes, but not for commercial contracts. For commercial contracts, changes must be bilateral. Now, take this with a grain of salt as well, because we recently had something similar, but on occasion, if the government tries to make a bilateral modification, first of all, you don't often have a lot of negotiation room. Second of all, if you do not sign it, there's always a chance that you get terminated or that they push it through as unilaterally somehow. I mean, we've seen this happen. I'm not even saying it's legal, but we have seen it happen. And frankly, a lot of times the client doesn't want to get into a big legal battle over it because they just want to get paid and have it be over with. But take it with a grain of salt. All right, I don't want to file a claim. The government and I just don't see eye to eye. I guess a claim is my only option, but those can be time consuming. So this is great, and this really is a very little known provision, but there is a FAR provision right there, FAR 33214, for ADR, Alternative Dispute Resolution. And it can be fantastic where, and I think this is a good kind of place to trust your gut, where there's been some miscommunication or something and everything's still pretty amicable and you really don't want to go into a full litigation claim, this is a great option. If things are just so far gone and you know it's not going to work out, I'm not sure I'd always waste my time on this, but you can have a neutral arbitrator, neutral mediator. It can either be someone from the agency or you can agree to pay for a private third party or split it with the government, whatever everyone agrees to. And in a nutshell, the good thing is if you request this, it really does pressure the agency to say yes. The FAR clause I cited here says if they say no, they have to give a very good reason and justification why they will not do it that way, since it does help to keep our courts not overwhelmed with these types of cases. All right, subcontracting misconceptions. And I would say these are more subcontract misconceptions because I think Annie had a couple of the subcontracting ones, but I'm a handshake sort of guy. I've just got an oral subcontract because I'm really a handshake sort of gal. I don't think anybody on here today needs a detailed explanation of this one, so I'll keep this quick. An oral subcontract is not compliant, not a great idea, for one big reason. If you are at all experienced in the government contracting realm, you know how different the contracts look than your commercial contracts look. They are very by the book when it comes to the FAR. We sometimes see an agency fail to put a FAR clause in here or there. Everyone makes mistakes. For the most part, they all contain a good amount of FAR clauses that are directly required by law. Now, it's not as simple as, whoops, forgot to flow down those FAR clauses. For some of them, it might be. For some of them, it might just be a bad idea that you didn't flow it down. But for others, they directly say, prime contractor agrees to put this clause or reference this clause directly in any subcontract under this work. So an oral subcontract would be violating that. Also, just don't. I mean, come on. It's, you know, it's an oral subcontract. Apart from the FAR clauses, how are you going to resolve disputes? How are you going to split profits? You know, I guess you don't split profits technically, but how are you going to distribute your payments to the subcontractor? There's so many things that if you came to me and said, hey, attorney, I'm an oral contract guy, I'd say, well, you're going to need to fix that real quick or find another law firm, because that is a headache waiting to happen. So you want to know what some of those FAR flow down clauses are. And like I said, some containing mandatory and some containing others. It's FAR Part 52. And I think our next slide's a little bit about those too. So I'll go into a little more detail there. Yep. Okay, my commercial agreement rocks. I'll just go ahead and use my commercial subcontract for federal work because my commercial agreement rocks. Same exact thing, oral or commercial agreements, both wrong for all the same reasons. Commercial subcontract is not going to have those FAR flow downs. It's probably not even going to reference the FAR, have any idea what it means. It could even have things in it that blatantly go against what federal regulations require. It's also just likely to be less than ideal from other standpoints. Federal government contracting is very, very specialized. The subcontract should be too. It's so important to know what has to go in those subcontracts, but also what should go in those subcontracts. There is not a subcontract that leaves our office that doesn't have probably 10 to 20 things in it that are not written down anywhere as a requirement, but we would refuse to hand a client a subcontract without those 10 to 20 things in them, because we just know firsthand how important it is to have those things in there. And so again, using a commercial subcontract is just not going to get you there. Additionally, this is about flowing them down. The whole kit and caboodle, I can and should flow down every single FAR clause in my prime contract. Can't call me non-compliant now, Mr. Fancy Pants Lawyer. I love that one. I didn't write it. It's adorable. So that is obviously a misconception. Now, this one is probably not as obvious for the reason why it is a misconception, but it has to do with what I said already. Many clauses are mandatory. Now, they're mandatory in a couple ways. There's some that flat out say this has to be included in your subcontract. There's others that say, for the purposes of subcontracting, subcontractor is also obligated to, you know, follow this rule. And where it says prime, it should say sub, and where it says government, it should say prime. And so that's another way it can be mandatory. So it's not even as simple as, you know, control fine for requirement to put into the subcontract. And then you have lots of others that give you, as the prime working for the government, certain rights and certain very specific privity of contract with the federal government type provisions. And so flowing some of those down just by saying we're flowing down absolutely everything is not your best bet. You could be giving completely nonsensical direction to the sub, and you could also be giving the sub more rights than necessary. I mean, that's not in a trying to, you know, withhold rights from your sub that they should be, it's really that they should not be entitled to them, that they have the ability to do certain things through you that you don't have with the federal government. So you get additional rights. And so flowing everything down is not great. I will tell you the only way we even allow it, where clients don't want us to go through every single FAR clause in every single contract, because that would take forever, is very carefully crafted flow down language that specifically calls out not flowing down anything that's not required, not flowing down anything that's nonsensical, not flowing down anything that gives the subcontractor a right that is only customary for the prime contractor to have. And even then, we still always suggest they take a look and see if there's anything else that they still want to flow down, even if it does not, or even if it falls within one of those exclusions. Okay, the fun ones, miscellaneous misconceptions. The FAR and nothing but. Oh, I love this because this was a quote from a government employee from when I first started, who will not be named. If it's not in the FAR, it doesn't apply. This is a direct quote, y'all. And I'm not saying this to cast fun on this government employee. I'm saying this to tell you how important it is that your clients, that your federal government contractors are their own advocates and have to advocate for themselves a lot, because there are misunderstandings of this very difficult interplay of laws. So a rule does not have to be in the FAR to count. For example, SBA regulations will apply to a lot of contracts, a lot of small, anything that's set aside, even though they're in 13 CFR instead of the FAR. The FAR is 48 CFR, if anyone doesn't know. For certain agencies, you will have additional regulations, DOL, DOD. You will sometimes have deviations. You even have statutes, which, excuse me, while statutes are generally interpreted and implemented via regulations, that is how they are supposed to work, there are still certain aspects of statutes that must be followed. Most of the time, you do not have to go to the statute. For example, there's lots of anti-kickback stuff, and all of that is also in the FAR. But I would not want to be out there arguing that I followed the FAR even though there was something in the statute I didn't follow. So it really does help to know all of the laws that apply to your situation, and it is not just the FAR. And my favorite bonus misconception. All right, we have heard everything here from NAICS, NEACS, NACIS, but NAICS, the North American Industry Code class, sorry, one more time, North American Industry Classification System Code is pronounced NAICS. And if you need a reminder, snakes, cakes, it rhymes with those words. Being able to just say NAICS correctly already shows those in the room that you know something about federal government contract, so it's a great way to start. And that is all we've got on set content. I will quickly and shamelessly plug a few things. I referenced our blog earlier. It is free, and it's free to sign up for the newsletter. And I would venture to say that basically every single thing we covered today has some kind of blog over it, whether it's a case or an actual. We do kind of common misconception blogs, we do frequently asked questions, we do back to basics where we explain things, and then we do some very high level ones on really, complex litigation. So there is something for everyone. There's something for your brand new contractor client, there's something for your, way experienced about to retire contractor client. Down there are phone numbers and emails. Again, don't hesitate to reach out to Annie or I or both. And then here are our books. These books run you like $8, $9 a piece, and they are all available. You can see on Amazon or on the blog. There's a little sidebar that has them all. And I really highly recommend them. I will say for the 8A program, there's a couple things that are out of date right now. I believe the economic thresholds have gone up a little since this is already a second edition of this book, but there's been a lot of changes. And then because of the Ultima decision, there's been some changes too. However, we're not going to put a new one out until we see a little bit of stability so that we're not having to continuously do so. But most of the regulations, policies, the cases in there are all very relevant and helpful, not just for those applying, but for those in the program. Pitfalls and procedures of size, protests, and appeals. Size protests and appeals are such a fantastic way to get your voice heard where you do not believe someone qualifies for a contract, and they're so much less expensive and easier to file than GAO and any other type of litigation. So great volume there, great book there. Small business size and affiliation rules, also great, helps you figure out if you are small. Joint ventures, lots of classic law there that has not changed at all. So I think that's all we've got, and I think Jody is going to take back over. Here are those links to our LinkedIn, our free monthly e-newsletter, and our emails one more time.
Phew, I think you need a drink of water after that. That was a lot of incredible information. So we do have a question, and we've got about 12 minutes or so left, everyone. So if you think any questions, please get those into the Q&A box now, or hit that raise hand feature so we can get the most value out of our remaining time. So ladies, we do have a question. Paul has asked, are large primes required to provide a reference or CPAR when requested? We have been told by a large prime we don't give subcontractor performance assessments.
So there is a rule on that. Will you take back over slides so I can, I'm not super tech savvy, so that I can pull that up real quick?
Yeah, sure, give me 2 seconds.
Take your time.
Okay, go ahead.
Lovely. There is a rule. Now there's kind of some like caveats in that rule. So I am going to pull it up for you, and I will also, I believe there's a blog on it. So if I can find that blog really quickly, I will put that in the chat for you as well. So, and I'm thinking, so I want to say that the answer is pretty generally yes. If you as a small business request a past performance review from a large business sub, they are required to give it to you, and the rule went so far as to say that the agency is also required to accept it. So let me double check that I'm not missing any of the requirements for that. Which was this? I know we've logged on it. I just got to pick the right keyword. Okay. Annie, if you can find it, go for it too. If that's the only question that we have right now.
Yes.
Okay, great. I just want to make sure we're not like holding up anyone else's questions. I will find it. Give me just a second.
So while they're looking that up, just because there's nothing scarier for a presenter than quiet time in a webinar, does anybody else, please, now's a great time. If you have any questions or comments that you'd like to add, there we go, getting a couple more in.
Great, and I did find it. So,
okay, go ahead.
New SBA rule on small business past performance also has implications for large businesses. And I say new, I think this was like 2022, but the final rule, which I do have a link to, essentially it says exactly what I said, but you know, as an attorney, I don't like to quote things without being sure, but it essentially does say that any large other than small prime has to provide past performance reviews to first tier small business subcontractors. I did miss the first tier part, so you can't be a second tier, you gotta be first tier. And the final rule is intended to help small businesses overcome that hurdle of moving from being a small business sub to a prime. So if you've got someone telling you no, again, I can't give you individualized legal advice, but what I can do, and I'm happy to do, is tell you that, okay, let me just read this really quick. When requested, the prime must provide the past performance rating within 15 calendar days. The rating must utilize the CPARS ratings found at FAR 421503. And that rule is, can I post let me just post a link. And
yeah, if you want to put it in the chat, I'll go ahead and click on the link. Or
Lovely.
I can make you presenter again.
No, I will just fine to put it in the chat. As long as I can. Oh, there we go.
Okay, fabulous.
So yes, they are required, and this is a newer rule, and we were really happy to see this rule. And I know we have a blog on it. I couldn't find it, but I just found the Federal Register summary of it, so that works for me. But it is
Okay.
very helpful.
So I'm going to go ahead and copy and paste that into the Q&A box, which hopefully you should be able to see, and then click on that link. All right. So here we have that again, Federal Registration, Federal Register. But I'm going to leave this up on the screen. But let's come back to, we do have another question. We've got a couple minutes remaining, and we can always come back to this. So I'm going to just let this sit on the screen. Tori asks, if we award a services order to an independent contractor, when we add them into our vendor database, can we classify that sole proprietor as a small business if they register using their EIN? What if they use their Social Security, etc.? Tori, do you want the mic to further explain that one?
I think I know what Tori's saying, and I'm not sure I have a concrete answer for you. I will say, if SAM requires, yeah, probably does. I think SAM does require an EIN versus a social. I could be wrong. But if SAM requires the EIN, then they would need to go off the EIN in order to count as a small business, a similarly situated entity, or whatever, just because every single entity that's going to be working on a government contract must be thoroughly registered in SAM. Now, if SAM allows them to use the social, then I wouldn't see any reason that that would matter. I'd even be happy to kind of take a look at that one and send you an email. If you want to shoot me an email if that didn't answer your question, or you go to SAM and realize you can do either, you can definitely shoot me an email on that one, because I don't know that one off the top of my head. I have not had that one before.
Okay, thanks, Terry. So she further adds, context for the question is a small business plan participation. So really what you're looking at, and I'm going to assume it doesn't really matter if they're using how they are giving that tax identification number. You're really trying to distinguish that employee versus a subcontractor. So if you have that, and I believe you covered that under one of your misconceptions, that if, how do you define what is the legal definition of employee versus subcontractor? And just
Sure.
having their social security number, are there other factors? That I'll turn over to you.
Sure. Okay, that helps. Thank you. So if you W-2 somebody, they are your employee. If it is any other kind of 1099 based contract, then they would be a subcontractor. And if you're talking about like a small business subcontracting plan, things like that, the only reason I brought up SAM is if you, so let's say you have a couple subs, and one of them you'd really like to be considered a small business in order to make sure you're meeting the limitation on subcontracting. So the way that the government is going to check that is by going to SAM. And so that is why I bring SAM up, because if they are registered in SAM as a business, as a small business, even if it's one person, there's a lot of one person small businesses out there. I am not a tax attorney, so I don't know for sure, but I believe to register as a business, you need an EIN no matter what. I could be wrong. Don't quote me there. Ask your neighborhood-friendly tax attorney.
I did find the blog we did on this.
Oh, good. What's it say?
Okay, so if you're a U.S. tax-paying entity, you need your tax ID number and taxpayer name. Your TIN can be either an employer ID number, so the EIN, or social security number based on your business structure.
Lovely.
Not sure if that's helpful, but
I think that's very helpful. Yeah. So yeah, depending on the type, because that's right, I guess, because if you create an LLC or a corporation, you're going to need an EIN, but if you do more of like an S corp or something, you may not. That's all very tax law-ish, but as far as the federal government cares, as long as you meet the qualifications to be a similarly situated entity or a small business, if you've got like a large business prime under SAM, and that's where they would go look to see what you've certified your size is and everything like that, then it should not matter which one you use as long as it's consistent with your local and your tax laws. So that was very helpful, Annie. Thank you. But either way, definitely either way, definitely a subcontractor unless you have a W-2.
All right, so any other questions? We've got a couple minutes left. Well, here's what I'm going to do. Oh, we do have, okay. So Paul says it's a great session. Just to confirm from the proposal section, if we have a clarifying question or an RFP that just came out, I'm going to rephrase this. If we have a clarifying question on an RFP that just came out, we do not have to wait for the Q&A deadline to call or email a question.
Correct. Absolutely. There's almost no requirements on what you as a contractor or the contractor can or cannot ask regarding clarification on an RFP, solicitation, or anything. Now, you may get a response from the CO that says, hey, the Q&A is in a week, ask it then. Or they may say, don't worry, we'll answer that at the Q&A. Or they may ignore you and then you can go ask it in the Q&A. You know, we see everything across the board. Most of the time, a good CO is going to answer you, but is then also going to tell you that they're also either going to make an amendment or they're going to put that in the Q&A so that everybody can see it. That's what they are supposed to do, unless it is essentially, like I said, them just pointing you in the right direction of something that you may have just missed. So yes, you really have almost no limitations. You can market yourself to that CO. Once that solicitation's out, you can ask questions, you can ask for help. They may or may not give it to you. The only caveat I said again is making sure that if you feel like they're giving you some insider info, I would make sure that they either indicate they're going to do something public, or I would encourage it just to avoid any kind of protest.
Fabulous, thank you.
Of course.
All right, well, I'm going to take the last 2 minutes. I have a question of my own, but before I do, just because part of the hosting obligation is if you come up with your questions and answers after the fact, you're more than welcome to reach out to any of our staff, reach out to myself, reply to the webinar invitation, get that question to me, and I am more than happy to forward those on to our presenters today, since we don't have their handouts available. Now, I've been talking to someone from the company and they will get those to me, and as soon as I have those slides with the watermark, then I'll go ahead and get those sent out. But I just wanted to let you know, here's our contact information to make sure that you can follow up with any questions if you come up with it after the fact. So I'm going to give we got last few seconds. Any comments, questions? All right. Well, thank you, everyone. Annie, Nicole, I really appreciate you joining us here today and taking the time to talk about these misconceptions and these mistakes that often are made based on assumptions and misconceptions. And I really appreciate you taking the time to join us today.
And yeah, we
appreciate
thank
you for having us.
Yeah, it was very, very well organized. Well, happy to come back anytime. Thank you so much.
Oh, fantastic. It's always good to hear that. Well, everyone, at this point in time, since I don't see any additional questions, I'm going to go ahead and let our speakers move on with their day. Again, thank you all for joining us today, and I wish you all a fantastic rest of your day.